This at any point in the future, let's say a couple months or so beyond this date, you always want to check to make sure that things have not changed since I left this video. Although these videos, this is my daily tips, so that's a shorter video on a topic that generally confronts a lot of clients or I find comes up often. My advice is generally more of a basic nature, more of a theory nature, so laws won't drastically change, but it is important that you do check just in case. So today's video is about what to do when you get a bad decision. And obviously I mean from a judge. If you make your own bad decision, then you have to live with that. But if you get in court and you have a decision that a judge gives you and you're dissatisfied with it, there's at least three things that you need to do. The first is you need to determine whether it is a temporary decision or a final decision. And not just on the issue itself, but for the case itself, because it's much more complicated of a question than it seems. For instance, if you make a motion for to relocate, or if you're in a relocation case and the court grants relocation and then orders a mediation session to discuss parenting time, that's not a final decision. Even though the issue on relocation is final, it's still what's considered temporary, or also called interlocutory, because there are other proceedings that will follow, whereas a permanent decision would have been just the child can relocate and that'd be the end of it. Very important distinction to make, which I'll explain in a minute why, but beware that not all judges and lawyers know how to make this decision the right way. So you need to get some really good advice and some clarity before you make this decision and determine where to take it next. The second step is, if you do have a final or temporary decision, you have to decide if you're going to reconsider it to the judge that issued the decision. One, if it's an interlocutory or temporary decision, you can reconsider that at any time before the judge. A lot of people, even lawyers, think you can only reconsider within 20 days. That's not the case. If it is an interlocutory or temporary decision, you can appeal it or you can reconsider it at any time while the matter is pending. If it's a final decision, you only have 20 days to reconsider to the judge that rendered the decision in the first place. Not going to go into the grounds for reconsideration. That's beyond the scope of this. I probably have a video on my website or my YouTube page that discusses it. The third thing to decide is, and you probably want to decide this along the time you're deciding whether or not to reconsider it, is whether or not you're going to appeal it. Now, you can appeal both a temporary and a final decision, but the time frames are different. Again, the reason why it's important to make sure you have the right determination as to temporary, interlocutory, or final. If it's interlocutory or temporary, you only have 20 days to file an appeal of that decision. If it's final, you have 45 days to appeal that decision. Real quickly, even though it's beyond the scope of this, one other quick thing to understand about an appeal is you can extend the time to file these appeals, both interlocutory and final, if you file a motion to extend the time to the appellate division inside of the time that you have to originally file the appeal. So it's either the 20 or the 45 days. If you file the motion inside of that time frame, you can ask to extend it. If you do not file either the motion or the appeal within those time frames, you may not be able to file them at all. I hope this helps. If it did, please give it a like and share it so that other people get to see it. If you have questions or comments, you can always email me at brad@micklenlawgroup.com or go to my website for information about texting and calling the office. Thanks.